Hello, I'm Richard Wilson. I'm a caseworker at the Standards Commission for Scotland. The aim of this video is to provide an overview of the Model Code of Conduct for members of devolved public bodies. I will begin by looking briefly at the Ethical Standards Framework, then move on to look at each section of the Model Code, which all devolved public bodies base their own Code of Conduct on, before finishing by highlighting the guidance and advice notes and further support offered by the Standards Commission. The overall aim of the Standards Commission is to ensure board members meet the high standards of behaviour the Scottish public is entitled to expect. The Standards Commission aims to take a proactive approach to raise levels of awareness and understanding of provisions in the Code. It does this by issuing guidance, advice notes and standards updates through training events and by answering queries from and providing advice to members and officers. Though the Standards Commission's overall aim is to prevent breaches of the Code from occurring, it also has an enforcement role through its work on adjudicating on complaints and imposing sanctions. Investigations into alleged breaches are undertaken by the Ethical Standards Commissioner. When the ESC prepares a report to the Standards Commission on a potential breach of the Code of Conduct, the Standards Commission has three options. 1. The Standards Commission can choose to hold a hearing. 2. It can direct the ESC to undertake further investigation. Or 3. It can do neither, i.e., take no action. If, at a hearing, a breach of the Code is found, the hearing panel is obliged to impose a sanction. The Standards Commission has a policy on the application of sanctions, which outlines the factors hearing panels will consider when deciding which sanction to impose, including the seriousness of the breach and any relevant aggravating and mitigating factors. The appropriate sanction will depend on the facts and circumstances of each individual case. A censure is the formal recording of the Standards Commission's severe and public disapproval of the respondent's conduct. A full suspension means that the respondent is not entitled to attend any meetings of the public body. This includes any committees and subcommittees, and also any meetings of any other body of which they are a representative or nominee of their public body. Partial suspension means that the respondent is not entitled to attend certain specified meetings or committees of the public body. Disqualification means that the respondent is removed from membership of the public body and is prohibited from being a member of the body for a period not exceeding 5 years. The Standards Commission, on removing and disqualifying a member from one specific devolved public body, can also direct that the individual is removed and disqualified from any other devolved public body of which they are a member. Now I will move on to look at each section of the Code in more detail. Section 1, the Introduction section, notes that members are required to comply with the substantive provisions of the Code, being sections 3 to 6 inclusive. Compliance is required in all situations and at all times where you're acting as a member, have referred to yourself as a member, or could objectively be considered to be acting as a member of the public body. The Introduction section emphasises that it is a member's personal responsibility to be familiar and to comply with the provisions of the Code, the law, and their public body's rules, standing orders, and regulations. It provides that members will not, at any time, advocate or encourage any action that is contrary to the Code. Members are urged to seek advice if they are uncertain as to how the Code applies, or if they need help in interpreting any of its provisions. Section 1 provides more information about when the Code will apply. The Code does not apply to a member's private or family life. It only applies when you're acting as a member, have identified yourself as a member, and/or when you could reasonably be regarded as acting as a member. In determining whether the code applies, the Standards Commission will apply an objective test and will consider whether a member of the public, with knowledge of the relevant facts, would reasonably consider that the individual was acting as a member of the public body at the time of the events in question. The code states that this can include when members are engaging in online activity. The Standards Commission's guidance on the code notes that it can be very difficult to persuade people that you can take a different view or even have an open mind in your capacity as a member of your public body from any view you may have expressed in your personal capacity. This is particularly the case when using social media, where the separation of public and private comments may be unclear to someone reading them, and where information about the membership of the public body may be readily available online or from different sources, for example, the public body's website. This does not mean that members are prevented from expressing views, rather that they are required to do so in a way that is compatible with the substantive provisions of the code, being sections 3 to 6 inclusive. This includes the requirement to behave with courtesy and respect and to maintain confidentiality. Section 2 of the code states that a breach of one or more of the key principles does not, in itself, constitute evidence of a breach of the code. However, it notes that the key principles can be used by the Ethical Standards Commissioner's Office in its investigatory role and the Standards Commission in its adjudicatory role to assist with interpretation of alleged breaches of the substantive provisions of the code. Section 3 of the code covers general conduct and makes it clear that the requirement for members to treat everyone with courtesy and respect includes in person, in writing, at meetings, and when they are online. The conduct expected of members online is no different to the conduct they should employ in other methods of communication, such as face-to-face meetings and letters. Before commenting or posting, you should consider very carefully whether you understand the immediate and permanent nature of any comment or post you're about to make, whether you would make that comment or post in person, face-to-face, whether you have such conviction in what you're about to share that you would be prepared to justify it if later challenged, whether you fully understand that even if you delete your post, it may have been screenshotted or retained in some way or automatically cached online, and that fully deleting content once it has been shared online is almost impossible to achieve. You should also bear in mind the potential impact on the public body's reputation and the principle of collective responsibility, and also any confidentiality issues that could arise. The Standards Commission has produced an advice note for members on the use of social media, which can be found on its website. Section 3 of the code also states that bullying and harassment will not be tolerated. The code notes that disrespect, bullying and harassment can be a one-off incident, B, part of a cumulative course of conduct, C, a pattern of behaviour, and D, can also consist of physical, verbal and non-verbal conduct. The code notes that it is the impact of the behaviour, not the intent, that is the key. Paragraph 3.2 of the code provides that members must not discriminate unlawfully and should advance equality of opportunity. Relations with employees. The code states that you must not undermine any individual employee or identifiable group of employees or raise concerns about their performance, conduct, or capability in public. This provision does not prevent you from scrutinising the performance of a team or service. Instead, it precludes you from making any public criticism, which is personalised in nature, about an individual officer or an identifiable group of officers. When you need to raise concerns in public about the performance, conduct, or capability of the organisation or parts of it, You must do so objectively and respectfully, focusing on the issues rather than any employees who are or were directly involved. You should, however, always bear in mind the key principle of duty, in that you have a duty to act in the interests of your public body, and the key principle of leadership, in that you have a duty to maintain and strengthen the public's trust and confidence in the integrity of your public body. The code states that you will not take or seek to take unfair advantage of your position in your dealings with employees, and that you will not bring any undue influence to bear on employees to take a certain action. The provision states you will not ask or direct employees to do something which they know or should reasonably know could compromise them or prevent them from undertaking their duties properly and appropriately. The Standards Commission has produced an advice note on relations between members and employees, which can be found on its website. The code notes that except where it is written into their role and/or at the invitation of the Chief Executive, members will not become involved in the operational management of their public body. The provision acknowledges that operational management is the responsibility of the Chief Executive and executive team. In general, if a duty is delegated to an employee, then it is likely to be operational in nature. The key here is whether the involvement is appropriate. Becoming inappropriately involved in operational management and/or operational decision-making can be a breach of the code. It can also damage your relationship with employees and have a detrimental effect on how they perform their duties. If you become too focused on operational matters, you risk losing sight of the bigger picture and may have less time to focus your strategic and scrutiny role. You may wish to refer to the Standards Commission's advice note for members on distinguishing between strategic and operational matters. This contains examples of inappropriate involvement, which include becoming involved in an individual staffing matter, insisting on reviewing internal policies and suggesting minor grammatical or formatting changes, and insisting on improving the content of policies that concern operational matters. For example, it may be sufficient to agree that the public body should have a policy on flexible or hybrid working for staff without approving the detail of such a policy. And another example would be trying to overturn a casework decision that has been delegated to employees to make. The code allows you to seek information about specific matters, cases, or a particular item of work, but notes that in doing so, you should be aware that employees may feel pressured by a member challenging their actions or appearing critical of a certain aspect of their work. The code contains a provision stating that you must respect the principle of collective decision-making and corporate responsibility. This means that once the board has made a decision, you are to support that decision, even if you did not agree with it or vote for it. If you fundamentally disagree with the decision taken by your board, then you have the option of recording your concerns in the minutes of the board meeting. If you remain discontented, you can ask the chair of the board for a meeting to discuss your concerns. Ultimately, though, if your concerns are not resolved and you cannot accept and support the collective decision of the board, you will need to consider whether it is appropriate to resign. I should note here that health and social care IJBs are not required to adopt the principle of collective responsibility in their model codes. Confidentiality. Paragraph 3.24 of the code states that you are only to use confidential information to undertake your duties as a board member. You must not use it in any way for personal advantage or to discredit the public body, even if you are of the view that the information should be publicly available. Information can become confidential in a number of ways, including in terms of the following examples: a public body employee or a member of the public has asked you to treat it as confidential. The public body has resolved or is likely to resolve to treat it as exempt information in terms of freedom of information legislation. Information which, under the data protection legislation or the general data protection regulation, contains personal data, the release of which would lead to a breach under those provisions. Sometimes the confidential nature of the material is explicit. In other cases, it may be clear from the nature of the information or from the circumstances in which it was provided. Providing the media with off-the-record briefings on the general contents of confidential information can seriously undermine and devalue the work of the public body and its committees. Sometimes it is a matter of timing, and that information may eventually be released into the public domain. However, you must respect the requirement for confidentiality, even if you do not agree with it, or consider that the information should be released at an earlier stage. For example, it can cause issues if you disclose information before employees are aware of it. They may need time to prepare communications for service users, and it could impact them personally. Gifts and hospitality. The provisions on gifts and hospitality are designed to avoid any perception that members are using their role to obtain access to benefits that members of the public would otherwise be expected to pay for, and also to prevent them from being influenced, inadvertently or otherwise, into making decisions for reasons other than the public interest. The Code makes it clear that the default position is that you should refuse all offers of gifts and hospitality, except in the very limited circumstances listed at paragraph 3.15 of the Code. It should be noted here that acceptance can include accepting the promise of a gift or hospitality. The exceptions under paragraph 3.15 are A. Minor items or tokens of modest intrinsic value offered on an infrequent basis, such as a pen or a notepad. B. A gift being offered to the public body. C. Hospitality that would reasonably be associated with your duties as a member, such as tea or coffee at a local event, or a buffet lunch included at a training event or conference. And D. Hospitality that has been approved in advance by your public body. If you're considering whether to accept an offer of a gift or hospitality that falls under one of these exceptions, you are still required to consider an objective test. This is whether a member of the public, with knowledge of the relevant facts, would reasonably consider that acceptance of the gift or hospitality in question might lead you to being influenced in your decision or discussion. You are required to advise your standards officer promptly if you are offered, but refuse, any gift or hospitality of any significant value, and/or if you are offered any gift or hospitality from the same source on a repeated basis, so that this can be monitored by your public body. Use of public body facilities. The Code prohibits you from using your public body's facilities A. imprudently, B. unlawfully, C. for any political activities or matters relating to these, or D. improperly. Preferential treatment. You must not use or attempt to use your position or influence to secure an advantage or to avoid a disadvantage for yourself or others. Section 4 of the Code is intended to give members of the public confidence that decisions are being taken in the best interests of the public and not those of you or your family, friends, or personal associates. The register is intended to be a public record of those interests which you know you have that might, by their nature, be likely to cause conflicts with your role as a member of the public body. Category 1 deals with remuneration and requires you to register any work for which you receive or expect to receive payment or reward. All paid work, no matter how casual or trivial in nature, requires to be registered. Category 2, other roles, requires you to register unremunerated directorships, including ones where you have been nominated or appointed by the public body. Category 3, contracts, requires you to register any interest you or an entity in which you have a substantial interest has an upcoming or ongoing contract with the public body for the supply of goods or services, or the execution of works. This category may overlap with Category 1, remuneration. If so, you should add an entry under both sections for transparency. Category 4, election expenses. If you've been elected to the public body, you're required to register a description of and statement of any assistance towards election expenses. Category 5, houses, land and buildings, requires you to register any interest, such as ownership, or other right you may have in houses, land and buildings where the objective test is met. This is where a member of the public with knowledge of the relevant facts would reasonably regard the interest as being so significant that it could potentially affect your responsibilities to your public body, or could influence your actions, discussions, or decision-making. If you are required to register an interest under Category 5, you will need to provide your public body's standards officer with the full address of the house, land, or buildings you own or have any other right or interest in. However, there is no requirement for any full address you provide to be disclosed on your public body's website or otherwise made publicly available. This means it is sufficient for the purposes of your publicly available register to simply identify where the property is located. For example, if you were a member of a National Park Authority, it would be sufficient to state, I own a residential property located within X National Park. Examples of other rights you may have in houses, land and buildings may include a right as a tenant, an agricultural tenant, as a trustee or beneficiary of a trust, or through a life rent. Category 6, interest in shares and securities, requires you to register an interest where A, you own or have an interest in more than 1% of the issued share capital of the company or body, or B, where, at the relevant date, the market value of any shares and securities in any one specific company or body that you own or have an interest in is greater than £25,000. The relevant date is defined in Annex B definitions as A, the date on which you were appointed, and B, every 5th of April following that date. I would note, in relation to this category, that the Scottish Government has written to public bodies confirming that this section is subject to the qualification that an interest in shares and securities in this category only requires to be registered if it is significant to, relevant to, or bears upon the work or operation of the public body. Category 7, gifts and hospitality. As you are no longer allowed to accept any gifts or hospitality, other than under the very limited circumstances outlined under paragraph 3.15, there is no longer the need to register any gifts or hospitality. Category 8, non-financial interests, requires you to register relevant interests such as membership of or holding office in public bodies, companies, clubs, societies, and organisations such as trades unions and voluntary organisations if the objective test is met. The Code states that non-financial interests are those which members of the public, with knowledge of the relevant facts, might reasonably think could influence your actions, speeches, votes, or decision-making. Category 9, close family members, requires you to register the interests of any close family member who has transactions with your public body or who is likely to have transactions or do business with it. This is to ensure there is transparency in respect of any potential influence that anyone close to you as a member may have over a transaction the public body has been involved in, which had an impact on its overall financial position. Section 5 deals with declarations of interest. This section of the code has been significantly revised. The revised section is intended to make it easier for members to determine when they have a declarable interest. The introduction of the first two stages, connection and interest, is intended to help you distinguish between situations where you simply have a connection to a matter and ones where that connection could objectively be regarded as having the potential to influence you in your role as a member. And in those circumstances, it would be a declarable interest. The third stage makes it clear that you must leave the room and cannot participate if you have identified that you have a declarable interest in a matter to be discussed. I will now consider each stage in more detail. Stage 1, connection. This is any link between the matter being considered and you or a person or body you're associated with. This could be a family relationship or a social or professional contact. It would also include anything registered as an interest under Section 4 of the Code. Paragraph 5.4 of the Code outlines matters that are not considered a connection for the purpose of the Code. This includes simply having previous knowledge or experience of a matter. A connection also does not include being a member of the body to which you have been appointed or nominated by their public body as a representative of the public body, unless A, the matter being considered by the public body is quasi-judicial or regulatory, or B, you have an additional personal conflict by reason of your actions, connections, or legal obligations. Having a view in advance on a matter to be considered at a meeting and discussing such a view with colleagues, employees, or service users would not in itself create a personal conflict that could be said to arise by way of your actions, provided, of course, the matter is not quasi-judicial or regulatory in nature. You're entitled to express views and opinions, and doing so before a meeting to discuss matters that are not quasi-judicial or regulatory in nature would not by itself create a declarable interest. Stage 2, interest. If you have a connection to a matter being discussed, you are then required to apply the objective test, being whether a member of the public with knowledge of the relevant facts would reasonably regard your connection to the matter as being sufficiently significant as to be likely to influence your discussion or decision-making. If this objective test is met, then your connection amounts to an interest that requires to be declared. The Code makes it clear that the requirement to disclose or declare interests applies both in formal and informal dealings with public body employees and other members, not just in formal board or committee meetings. You should not assume that employees and others will know or remember what your interests are. Stage 3, participation. If you have a declarable interest, you cannot participate in the discussion or any voting on the matter. You must leave the room, or if it is online, you must leave the online meeting. This is not only to ensure you do not influence other members, but also to avoid any perception you could be doing so. You're only required to provide enough information when declaring an interest for those present to understand why you have a declarable interest. The Code notes that in some circumstances, members may consider it appropriate for transparency reasons to state publicly that while they have a connection to a matter, They do not consider that it amounts to an interest, and to explain why that is the case. Section 6 of the Code deals with lobbying and access, and distinguishes lobbying from helping service users and community engagement. The Code explains that lobbying is where a member is approached by an individual or organisation who is seeking to influence them in their capacity as a member of the public body for financial gain or advantage. The Code requires members to have regard to the objective test in deciding whether they should, and if so, how, to respond to such lobbying. This is whether a member of the public with knowledge of the relevant facts would reasonably regard your conduct in responding to the lobbying as being likely to influence your public body's decisions. It is legitimate, in terms of the Code, for you to take up a service users inquiry with the relevant employee. You can ask questions about how a service has been delivered, and you can seek information on progress on behalf of a service user, but you should be careful not to stray into operational management. There are two annexes to the Code. Annex A, breaches of the Code, outlines how complaints are investigated and adjudicated upon, the sanctions that are available to the Standards Commission should it find a breach of the Code at a hearing, and that the Standards Commission can impose interim suspensions. Annex B contains some definitions in order to provide further clarity. The Standards Commission has published a comprehensive guidance document on the Code. The guidance includes numerous illustrations and case examples. Some are taken from real cases in Scotland, Wales, and Northern Ireland, and some are based on made-up scenarios. You can also find advice notes covering a wide range of topics as shown on the screen. These notes also include examples and scenarios where appropriate. The Model Code, guidance, and advice notes are all available on the Standards Commission's website, along with information about forthcoming hearings and written decisions of hearings that have been held. If you have any questions on the Code, or any of our guidance, advice notes, or other documentation, please don't hesitate to email the Standards Commission at inquiries@standardscommission.org.uk.